Good afternoon, everyone. Thanks for getting on. My name's John Ferrante. I'm the Director of Government and Industry Affairs for NERCA. We have our paid family medical leave webinar on the Massachusetts state law. I'm glad everyone could get on. A few housekeeping items. The webinar will be recorded, so we'll make that recording available to everyone following the presentation. Also, I have everyone muted currently. If you have a question, there should be a little questions box or a chat box on the GoToWebinar tool that you can enter in any questions you might have, and I'll try to answer them kind of as I go along. But if not, I'll try to circle back to them, at the end of the sections or whatever. Also, there is a handouts section on the GoToWebinar tool as well, and that has some. It has a copy of this presentation that you're about to see, as well as some handouts the state of Massachusetts created explaining some of the items that we'll be going over. So I'll try to call those out as we go through as well. Like I said, there's a great picture of me up on the screen right now. Hopefully everyone can see that. My contact info is there if anyone has any questions that they want to ask after the fact, or just get in touch with me. But here's our agenda for today. If we're on the webinar that we did back in, I want to say it was in June, there will be a little bit of repeating information, but I have tried to call out some of the new details in this red color where it says new developments. That's an entirely new section of the presentation. And anything else that's kind of been added into this slide deck as more information has come out will be called out in red. So the basic agenda here will be a kind of background of where the law came from, an overview of the law itself, what does it require, funding for the program, for who's going to pay for the cost of leave, an example, so it'll kind of break it down about how the program itself is going to work, some of the complicating factors and new developments that go along with the law, and then similarly key problems, what NERCA has been trying to do, and then a critical employer timeline, which hopefully everyone who's doing work in Massachusetts has met some of the initial requirements already. I will still highlight them just so if you haven't done it, then at least you can get on the right side of it sooner rather than later. But hopefully it'll be informative for everybody. So basically, the background here is a little more than a year ago, the grand bargain was signed into law, and that was basically employer groups and some more activist organizations came together and came up with a grand bargain, which was increasing the minimum wage, creating a sales tax holiday, and also this paid family and medical leave program. You can see below there's an implementation timeline for paid family and medical leave. The draft regulations came out in the beginning of the year. There was a public comment period that ended just before the summer. And then you'll see some of the more recent deadlines, the employee notification deadline. So if you haven't already informed your workforce about the benefits that they will be receiving and about the payroll deductions that will be coming out of their paychecks, that was supposed to be done by September 30th. And then right after that, you'll see on 10/1, the payroll deductions were supposed to begin. A new detail that we've kind of been tracking is private insurance exemptions. So employers who are going to provide the same benefits through a private insurance program have until December 20th to file for an exemption from the state payroll deduction, because you'll see after that, by the 31st of January of 2020, that's when all of the withholdings are supposed to be contributed, along with some of your other taxes for that quarter one. And then on January 1st of 2021, that's when paid medical leave will begin. So employees will be able to take that paid personal medical leave. And then on July 1st of 2021, that's when paid family leave begins. So like parental leave for new fathers, or someone who stays home with a sick parent or something like that. So what does the law require? I mean, I've given you a little bit of background on just talking through the timeline, but basically employers with 25 or more employees must contribute to paid leave. The way that that's going to work is through wage replacement. So I was talking about the payroll withholdings, and that's how the state is going to fund the state plan. And similarly, the private insurance options, you'll see a private plan is highlighted in red. The private insurance options we're learning are going to be funded through a similar mechanism, where it'll be based on a percentage of employees' gross wages. One of the wrinkles in the law is that health insurance coverage must be maintained by employers while on leave. So if you provide health insurance for your employees, you have to continue to pay your portion of the premium, regardless of if it's 50% or 100%. You have to continue to pay that portion. The benefits themselves, 20 weeks of personal medical leave, that's basically defined as inpatient or ongoing treatment, for the individual themselves. 12 weeks of family medical leave, which is, like I said, a parental leave for a father or caring for a sick family member. It's interesting, when I say parental leave, I mean, paternity leave, because the mother would actually be able to take the 20 weeks of personal medical leave for maternity leave, because that's obviously more of a medical procedure. And then combining those two, you're able to take 26 weeks total in any given year, as long as you have met the qualifications, which I'll go over as well. And then similarly, there's also a service member component of this, which allows for an injured service member or a newly activated service member to take time off to be with their family. And the wage replacement itself is calculated on a formula, which it's kind of complicated. You can see below, but basically it's supposed to be less than the average weekly wage. And it does have a cap of $850 per week of a maximum wage replacement based on that formula. So eligibility for leave. So in order for an employee to qualify to be able to take their leave, they have to have at least 15 weeks of earnings and have made at least $4,700 in the last 12 months. So that's in the preceding year. So, I mean, it's not a overly burdensome eligibility requirement. It's something that, probably in this economy, most people are going to be able to hit. There is a 7-day waiting period for paid leave. A lot of that is for administration, for them to verify that it's a valid claim, during which time you can use the earned sick time that accrues in Massachusetts for every 30 hours work to get the 1 hour of sick time. For personal medical leave, there are documentation requirements where you're going to need a doctor's note in order to take that leave. And kind of the same thing for family leave. You're going to need, documentation if you, gave birth to a child or adopted or are going to be deployed. Then you need that kind of paperwork to submit to the state. Yeah, so then similarly, I kind of covered it, the parental leave and the service member leave also need that documentation as well. Here's kind of a more in-depth breakdown of kind of the documentation requirements. I'm not going to cover them, in too much detail because everyone will have a copy of the presentation, but you can circle back and look at those. There are specific documents and information that has to be contained within those documents. So that you can judge how long the leave is going to last and whether or not it meets the criteria required for leave. So getting into employer requirements, this is a little more important to the employers. The documentation requirements are going to be reviewed either by the state program or by a private insurer. So it's a little less of concern to you. But once those documents are received, the employers, you'll see in the second bullet point that the Department of Family Medical Leave, DFML, or even your private insurer could request this kind of information from you as an employer, which would be wages and earnings for the past 12 months, a description of the position, their average weekly hours, if they've ever taken any other kind of leave, if you have your own paid leave policy, and then also if you believe that it's a fraudulent claim, this is the time that you'd be, given to speak up and say, I don't really believe that this request is on the level. In addition, all of the payroll contributions, if I roll back to this first bullet point, have to be done through the Department of Revenue's Mass Tax Connect system. So if you haven't already signed up for that, that's the online portal for the DOR in Massachusetts. If you aren't already signed up for that portal, you should get on that and make sure that you're submitting your quarterly information through that. So where it says contributions must be paid within 30 days at the end of the quarter, that's why the contribution date for the Q1 withholdings is January 31st of 2020, because that's 30 days after the start of the end of the quarter. More employer requirements. Employee notification. So this is what I was referring to on the timeline. Employees must notify employees no later than September 30th and put up a workplace poster. That's just kind of in your main office where you'd put all the other required, notifications. Also, one of the handouts on the GoToWebinar app that I've included is the employee notice for employers with 25 or more employees. So if you haven't done that, I would take a look at that handout and try to get that out to your people as soon as possible. Hopefully everyone's already done this, but the state did provide, a template for the notice. So if you did do it and you're kind of unsure if you did it correctly, I'd just compare whatever you used with what the state provided and make sure that everything's in there. I guess even more going in depth here, there was originally a little bit of confusion surrounding the written notice requirement, because it suggested that employees must acknowledge receipt of the notice by signing it and returning it to the employer. That, was determined to be a little too onerous on the employers, especially when there were employees who were refusing to sign it and all of that kind of stuff. So the department did issue new guidance, highlighted there in red, which just says, in the event an employee fails to acknowledge receipt, the department shall consider an employer to have fulfilled its obligation if it can establish that it provided to each member of its workforce the notice and the opportunity to acknowledge. So as long as you have some paper trail that says, in this paycheck on this week, we sent out the notice, and you have some proof of that, that should cover this requirement for you. And the department also said that electronically distributing the notice was also allowable. So if you did it, to all company emails or anything like that, that would all work as well. So funding, we kind of got into it. It's so again, I added the red letters at the top, state administered wage replacement contribution, because as you'll see when we get further into the presentation, the private insurers have a sort of different but similar system. But basically, the state program's funded by a 0.75% payroll deduction on gross wages, which is split between medical leave and family leave. So the state has determined that a 0.62% payroll deduction will pay for the medical leave, and a 0.13% payroll deduction will pay for the family leave. And that's split again between employers and employees. If you're an employer with 25 or more employees, then you have to pay the 60% of the medical leave contribution, which ends up being the 0.372% of wages that you see below. And an employee pays 0.378% of wages, and that will be regardless of whether or not they are in a company of 25 or more. So if you're an employer with less than 25 employees, you do not have to pay the 0.372% that an employer owes, but your employees still have to contribute that 0.378%. So you will just be withholding that 0.378 instead of contributing as well as an employer. And another thing, you know, for certain individuals, C-level or whatever, the payroll tax is only on the first $132,900 of earnings. That's based on the Social Security calculation, so that'll change over time. But as of, you know, this current withholding period, you only have to withhold up to that limit. Employee and workforce count. So if you don't know whether you are an employer of 25 or more, the state was pretty specific in spelling out how that calculation would be done. It's basically you have to annually calculate it based on your W-2 employees, including full, part-time, and seasonal. So anybody that gets a W-2, and there's also a provision that if you have 1099 employees, if they make up more than 50% of your workforce, then you have to count all of them into your average. If they make up less than 50% of your workforce, then you don't have to count any of them. So for each pay period, you add up the number of W-2, and then if you fall into that 1099 category, you add them up as well. And then you divide by the number of pay periods to get your average workforce. Self-employed, you know, people with small, you know, businesses, they can opt in if they, you know, want to, if they think this benefit would be good for them. And that would allow them to collect from the state if they decide to take leave. There is a minimum opt-in period of 3 years, so it's definitely a decision that should be carefully weighed before just jumping in. This is another question that we get a lot about kind of employer geographic requirements. So, you know, if you're an out-of-state contractor or you have an employee who lives out of state, are they covered by this program? And essentially, the Massachusetts law, it's the same as the unemployment insurance for the state. So if you're paying Massachusetts unemployment insurance on an individual, then you should also be withholding the funds for the paid family medical leave. The words that the state itself used were if the service was localized in the state or out of the state, and whether or not the service depended. I mean, it's a very convoluted description, which I included below. So if anybody wants to read this and tell me if they have another interpretation of it, I'd be interested to hear it, because it's difficult to make heads or tails of it just reading it through, you know, on the initial brush. But from what we've been told is pay attention to mass unemployment insurance, and if you're paying that, then you likely should be making the paid family medical leave payments as well. Getting into the employment benefits, there are a whole host of benefits that are within the definition of employment benefits, which you can see above: health insurance, group life insurance, disability, sick leave, annual vacation, education benefits, and pensions. The most important one is going to be the health insurance benefits, because those are obviously the most universal of all the employment benefits, and there is a specific clause that says that the employers shall continue to provide for and contribute to the employee's employment-related health insurance benefits. So while an individual is out on leave, you have to make sure that that you as an employer at least maintain their benefit obligation. So how is this going to work? Here's a basic example. So in 2021, if you're part of a state program, you're going to collect, and let's say Skylight Inc., has 25 or more employees. They're going to make their contribution of 0.372%, and Joe Sixpack's going to make a contribution of 0.378%, and that comes out to about $350 over the course of the year. And that will, pooling all that money together, the state expects that they'll have enough to cover contributions in the following year. So Joe gets a serious medical condition. How's that going to work? He gets his doctor's note, submits the claim to the department. The department confirms the information with the employer and makes a decision after no more than 14 days. So that's where that 7-day kind of waiting period comes in. But it could be up to 14 days. But once they make a determination, they approve his application and start paying him his weekly benefits, which you can see I ran that complicated formula for Joe, and it came out to like $730 a week. So he didn't max out at $850. But he is getting a fairly generous benefit back while he's out on leave. At the same time, Skylight continues to pay their 50% of the health insurance benefits, while Joe continues to pay his portion of the premium as well. And that's how the state spells it out, is that the employer is not responsible for any more to the health insurance than they've already been paying. And it's expected that the individual will keep kicking in, especially if they're relying on the health insurance, obviously, for whatever issue they're dealing with. Similarly with family leave, Joe says, I'm going to have a baby, in a few months, has the baby, submits the birth certificate and stuff to the department. They approve his claim and do the same thing, pay out the benefits, and he pays the health insurance along with the employer. So, I mean, in this example, Joe ended up taking all of his 26 weeks in 1 year. He worked for a few weeks, then took his medical leave, then worked, through the summer, and then took his family leave. So you can see how the multiple uses of the paid family medical leave program, as well as, how it might work out in a single year. So some complicating factors here. And I've listed a whole bunch of them, but intermittent leave, that's something, that I would definitely pay attention to, because that could end up being a major issue. Basically, if they can get a doctor's note saying that they need to be out, Tuesday and Thursday for treatment or something like that, then an employer is required to allow them to take their leave in that manner. Some employers might like it better, you still have, a little bit of production or whatever, but it could also make scheduling and all those kinds of things a little more difficult. The state did build in some assurances and say that if, the employee starts to miss time that they're supposed to be at work when they're on an intermittent leave, then they can be disciplined. So it's not like you're completely hung out to dry, but it could be an issue going forward. Another question we get a lot of is a reduction of benefits. So if a worker is taking is collecting from multiple entities, and I'm not exactly sure how that might work, but if they're collecting short-term disability and they're out on paid family medical leave, how does that work? And the way that works is the state will calculate the other benefits they're receiving and reduce the benefit that they are giving out proportionally. A little tweak of this, which is something employers definitely need to be aware of, is that if you have an employer-provided short-term disability policy, that does not reduce the benefits unless the total amount that they would be receiving in any 1 week exceeds their average weekly wage. So aside from that calculation, where we would suggest for most employers is especially Massachusetts only employers is if you have a short-term disability policy, I would look at trying to eliminate it or lessen it to a degree that it's not going to encourage some abuse of this system as well. So I'd consult with your experts or whoever is managing that policy for you and see what they think, but definitely pay attention to that. Similarly, if an employee is out on medical leave and says, when they apply, they say they need 4 weeks and it turns out they need 6, they can apply for an extension. So that's another thing to be aware of is individuals are able to extend their leave if they can get another doctor's note saying that they need that. Job protection, obviously, it's similar to earned sick time. An individual who goes out on leave is supposed to be restored to the same position that they were at when they left. And anything, any kind of discipline or anything that goes along with that goes against an individual who goes on leave will be looked at as retaliation. So it's something that an employer definitely needs to be wary of. There is, however, the same layoff provision as in the Massachusetts Earned Sick Time law. And basically it says if you have laid off other employees of equal service credit and status in the same or equivalent positions, then you do not need to hire back the employee on leave. That doesn't mean that you get to cut off their health insurance or do any of those kinds of things. You still have to maintain their health insurance while they're on leave, but you do not need to bring them back into your employment if you've had a layoff while they are out. Another little, we got a question here. Let's take a look. So we have a question, and this goes back to the shared cost of the health insurance. So if an employee is out on leave and they are responsible for paying their portion of the health insurance premium, but they choose not to pay it, can the employer drop the health insurance coverage? If so, how long until the employer can drop the coverage? I haven't seen a specific answer to this question. My feeling would be that your health insurance provider would probably have a better understanding of it if they've been in communications with the state. I can look at the regulations a little bit more, and I have your name here so I can get you a better answer. But yeah, I would talk to the health insurance provider and see how they are planning on handling that. I mean, I guess at most an individual would be out for like 26 weeks, but at the same time, I don't know when or if the health insurance provider would say, they're not paying, we're going to drop them. Because, I guess theoretically the program is supposed to work where an individual needs the insurance when they're out on leave, so they would continue to pay for it. But as we know, that might not be the case with some of these people. So, but I'll try to get a better answer to that question. But otherwise, I would encourage talking to your health insurance provider because they might already have an answer. So in red here at the bottom of the complicating factors, there is a provision that was inserted into the regulations, which employers should be aware of, which is the ability to use a fitness for duty test for anyone returning from medical leave. This is definitely something I would suggest to protect yourself from somebody, who got shoulder surgery or whatever is trying to come back and might not be able to do the job anymore, but doesn't want to lose the work or tell you that. So you need a specific policy determined by the health condition. So, if, whatever the shoulder injury is, knee injury, all those kinds of things, you can come up with a fitness for duty test, which is basically give a list of the job description and type of work and all those things to the doctor. And the doctor has to sign off and say, yes, this person is cleared to resume all these kinds of activities, so that, if somebody does, go out on leave, they aren't coming back, getting hurt again, and then, going out on you on workers' comp or something like that. So definitely I would start looking at a fitness for duty test for some of your more prevalent, injuries or health conditions that an employee might come down with. So new developments, this is where I would get into the private insurance exemption. So basically, we knew that it would happen eventually, and it seems like over the last couple months or whatever, private insurers have really started coming up with products and policies that will cover the wage replacement portion of the law. So it's not going to affect the health insurance. That's still going to be done through your through your health insurer. But the wage replacement, so rather than taking out the 0.75% out of people's paychecks, it's still going to be funded the same way. The private insurers are basically saying we're going to take, for the most part, the numbers we've seen have been about 0.5%. So it's significantly less. They say we'll take less out of their paychecks, and when they get, go out on leave, we'll pay them from the insurance provider rather than applying to the state. They'll apply to the private insurer. And, I have listed a few of them here that are providing it: Guardian, the Hartford, Prudential, Sun Life, Standard, et cetera. Every time I go back to it, it seems like there's more and more policies out there. Some of the benefits that we see is the private insurers aren't asking for any contributions prior to 2021 when the benefit can actually be taken. So if you apply for a private insurance exemption, you and your employees don't have to pay anything before 2021. Like I said, the pricing appears to be a lot more competitive than the state. So the state's trying to build up a whole new bureaucracy and a whole new program. It seems to be an expensive undertaking, and they're building that into the wage withholding. And so the issue there is that obviously the private insurers who are already capitalized, they can undercut the contributions the state is seeking. Again, talking about the bureaucracy, as we know, the state isn't always kind of the most efficient reviewer of claims, and also is a little more forgiving of some games when they get played. So we would think that private insurers would be a little bit more strict and a little more employer friendly in terms of trying to make sure that every claim is completely legitimate and every individual who's applying for leave really needs it. And then finally, we believe that the private insurance market will probably attract some higher quality employers, ones that are more well established, things like that. So they are probably going to be able to keep their costs down, whereas the state, similar to Medicaid or any state program, is going to have to cover everyone, and that includes probably some of the more costly individuals in the long run. The challenges are, it's kind of the same for the state, but a lack of experience. The insurance carriers are just pretty much winging it as well in terms of what this is going to cost. But that's the case with the state too. So I expect the fluctuations are going to it's going to happen for both of them. The other thing is employees might not like the private insurer as much as going through the state, probably for the reasons that I mentioned, which is the private insurer is a little more likely to scrutinize any of the applications and things like that as well. Although they might love the private insurance because it's taking less money out of their paychecks. So you never know. So the exemption process, it's going to have to be an annual application to the Department of Family Medical Leave through the Mass Tax Connect, the DOR portal. There are several videos on the state website and things like that that are that kind of really walk you through the process. But regardless, the deadline for the contribution or for exemption, I don't know why I said deadline for exemption is December 20th, 2019. And the applications are processed within 1 to 2 days. The hardest part here will be with it getting closer and closer to December. Obviously, the private insurers are going to get more and more people interested in their private insurance options. So if you have, an insurance broker or somebody that does that for you, I would definitely, and you're interested in this, I would definitely reach out to them and get that ball rolling. If you don't have that kind of person, feel free to reach out to the association office, and we'll be happy to, work with you or try to help you in whatever way we can. One thing to note is I did say, obviously for 2020, if you apply for an exemption in this December, you don't have to make contributions through 2020. The state is already aware that some people might think, oh, well, I can just opt out and then opt back in 2021. And they have already said anybody that does that is, we're definitely going to collect the back payment of the contributions, and we're exploring potential fines for that kind of behavior. So anybody thinking of gaming the system should probably think twice, I would say. Another kind of new development is the Federal Family Medical Leave Act, and that's just something that we wanted to bring to your attention because it's been in place since 1993, and very few people take it because it's an unpaid benefit. Basically, it's just a job protection benefit. If you need to go out for maternity leave, you're supposed to be able to go out and come back. That kind of thing. The one sort of wrinkle there is that we've recognized it does have the same health insurance benefits as the Massachusetts paid family medical leave law. So, if employees come to find that out and, times are slow or something, they might be interested in maintaining some of their health benefits while they are out of work. So just something to be aware of that we weren't previously kind of in tune with that fact, but basically you're allowed to take 12 weeks of leave in any 12 months, and during that time the health insurance has to be maintained at the same level. So it's the same kind of dilemma as we're encountering with the paid family medical leave law. But again, there's less of an incentive to take FMLA because it's an unpaid benefit. So key problems. Here's some of the more, I kind of already called out the geographical one. It's not entirely clear about which employers and which employees are covered. I think we have a pretty good rule of thumb, but that hasn't, been entirely spelled out. And another big problem is the tax implications of the payroll deductions, whether it's before tax or after tax. The state has applied to the IRS for a ruling on it, but they haven't gotten that determination yet. So the website's basically like, we're still waiting. But it does say they expect that it's going to be an after-tax deduction. So just so everyone's aware for their own purposes. But you could definitely talk to your own accountants and see how they're treating it. For the moment, we're hopeful that prior to the contributions being made in January, there will be further clarification of it, but it's not entirely clear. So NERCA, obviously we've been very in tune with this issue since it kind of got raised, a year ago. We've met with the Executive Office of Workforce Development and the Department of Family Medical Leave to talk about the regulations and how they affect our contractors and all of that kind of thing, including the layoff provision and all of that was very important for us. We've been trying to inform everybody as much as we can. We have the NERCA newsletters, and we've been doing it at some of the board of directors meetings, and then obviously these webinars are a big piece of it as well. We're totally available. If you have specific questions, you can absolutely feel free to contact me, and I'll be happy to answer them as best as I can. I'm going to go back for an answer on the dropping health insurance coverage, but yeah, I don't want to misinform anybody, but yeah, I've put a lot of time into reading these regulations and trying to understand the program. So feel free to reach out. Again, back to the critical employer timeline, you sort of saw an illustration of it, but September 30th, 2019, that was the employee notification. They have some of the the employee notices built in right there. The payroll deductions began on October 1st. Then you have the employer exemption on December 20th, and the first submission of the payroll deductions at the beginning of next year. Some additional resources, like I said, the Massachusetts website, it's actually one of the better websites in terms of understanding this program. You can go to the DFML website and it kind of gives you a nice breakdown of it. There is a page on it that shows you how to do your employee count if you're not sure if you're a 25 plus employer. Registering with Mass Tax Connect, if you aren't on that DOR portal, you definitely need to be. So I would go to that link and learn how to register. And then similarly, a payroll contribution calculator, you can kind of see what it's going to cost you over the course of a year, depending on the makeup of your employees and how much they get paid and stuff like that. I'll leave some time here for any more comments or questions that people have. It seems like we used most of the hour, but yeah, if you have a question, please feel free to put it in now. I will email everybody who registered a link for the recording and some of the handouts as well, which include the presentation. So everyone should get a copy of that. But if there are any questions, definitely feel free to ask them now, and I will circle back on that other question as well. Here we go. What happens if an employee reaches the cap with one employer and then changes the job to a second employer in the same year? I'm just trying to understand the cap. Is that the cap on the amount of leave that they can take? Because you can only take, no matter how many employers you're with, you can only take 20 weeks of personal medical leave and 12 weeks of family leave, no more than 26 weeks in a year. If you're talking about the cap, the $132,000 cap on contributions, then I'm not exactly sure how that would be treated. I guess would probably have to be up to the state to recognize that the cap had already been reached. I'm not exactly sure about that. Getting some good questions here. So I'll take a look at that one as well and see if I can figure that out. It seems like they're concerned with the income cap in terms of how much income is subject to the payroll withholding, which is currently set by the Social Security limit, which is $132,900. But I don't know if they change employer, then I'm not sure how that's treated. Good question. Yeah, it would have to be done through the state, I would assume. DOR must be able to track that, but I don't know how they would give the withholding back. That's a tough one. Is there any other questions? I know there have only been 2 questions, and I have to get back to you on both of them. But hopefully the rest of the presentation helped answer some of the other questions that are out there. And if not, there's the phone number and the email, and feel free to reach out to me, or I'll be sending you out the presentation and everything shortly. And it'll be from my email address, so feel free to reply back if you have a question there as well. Anyway, thank you everyone for getting on, and I guess we have another, I guess I should promote the other webinar we have coming up is November 6th. It's going to be with Philip Siegel. and it's going to be a good one about real life case studies from some of the court cases on employer liability issues and things like that. So definitely jump on that if you're interested, and thank you all for getting on.